So this panel picks up after passage of the remarkable legislation which we heard about this morning. And we also heard that it didn't figure out every single issue. There was still other stuff left to be sorted through. And so that's what this panel focuses on a little bit. Um, the post legislation developments is actually quite vast. And so I want to direct your attention to an article that Bob Lane wrote, and Bob is at the middle of the table here. He wrote an article that was published in 2015 called The Remarkable Odyssey of Stream Access in Montana that actually works through the whole chronology up until 2015. So it's a great resource. If you are a CLE person, you got these materials in writing, and they're also online on our webpage. And the Public Land Law Review published this document, and you've probably seen we've got law review students running around today helping. And so I want to say thank you to the Public Land Law Review students for all of their help. And to my left, I have Chief Judge Russ McEllier, who's Chief Judge of the Water Court, and then Bob Lane, who's retired Chief Legal Counsel for Fish, Wildlife, and Parks, and Mark Agonis, currently working for the Nature Conservancy, but here mostly because of his past experience as a lobbyist for Montana Trout Unlimited. And they're going to take selected pieces of the story because it's a little bit more than we can cover in comprehensively. And I'm going to just guide them with some questions. So I am the fourth wheel up here right now. So to begin, what I wanted Bob Lane to do was give us an overview of what's the arc of the legal evolution of this law after the legislature did this remarkable job of getting the bill passed, getting it signed. What came next? And it's a pretty daunting task, and I gave him 10 minutes to just blow through it. But we're going to take then a few of those ideas. We're going to take in-stream flow legislation, which has been mentioned a little bit, and talk about that, and the bridge bill and the work that was left to do on bridge access, and a little bit also on Mitchell Slough. So we're going to touch on those in more depth. So my first task then is to turn it over to Bob for an overview of all these developments.
Thank you, Michelle. Michelle has emphasized to me that I've got 10 minutes to do this. So it's going to be a flyover at about 10,000 feet, trying to give some context of what all has happened in the last 30 years after the 85 session. And in doing that, hit some of the high points that I think that need a little more emphasis. And then we wisely selected out two major subjects here, bridge access, and then the Mitchell Slough case, which is an issue about when something is no longer part of a river but has become a ditch or not. And those two things we'll be able to spend more time on, so I'll just note those as I go through this. I'm also reminded, and this comes sort of home to me right now, that I always understood that Mark Twain had wrote to somebody saying, or writing, I would have written you a shorter letter, but I didn't have the time. Well, Michelle has made sure I don't have the time, so I've got to try and do my due diligence here and make this as meaningful as I can within the time. There's a couple things that I think I can describe as themes that follow through on this. One is this: if you're an opponent of stream access, what do? A straight-on attack of the stream access bill to undermine it is one thing. We'll discuss that a little bit, of those couple efforts that actually occurred. The other thing is to basically chip away at stream access by taking sort of parts of it away with limitations or qualifications. And those are going to be primarily when we get to bridge access, which was opposed, and to the Mitchell Slough case, which has significance as determining when is a stream and when it is a ditch. So to start off with here is that in the first session, 87th session after the stream access law was adopted, there was another bill in that session that basically would prohibit the use of the bed and banks. And if you understand stream access, you understand how significant the use of the bed and the banks is to Montana's stream access. That is sort of the heart of stream access, to be able to use the bed and the banks along with floating for fishing and other recreational activities. That concept was actually in legislation in the 83 session. It was a concept that was amended and then taken out of House Bill 265, the Stream Access Bill, and it appeared in other legislation during the 85 session. The other attack directly on stream access basically was to claim that the use of the bed and the banks was an unconstitutional taking without just compensation. That decision was made by the Supreme Court in 1987 after extensive briefing and argument at the district court and at the Supreme Court. And basically the court said that, yes, that was an issue, and we find the statute is constitutional, except for a few provisions. No other analysis was presented by the court there. And Judge Morrison basically said there are a few things that just go too far. Big game hunting, permanent duck blinds, permanent boat moorages, and it's unconstitutional to make the landowner pay for portages, and that you can't camp unless it's absolutely necessary to utilize the water. So those things were the result of that. The one issue here with that decision was it didn't really say much about the takings claim. There's an attorney fee case a few years later in 1983, and basically the court said, basically, as the Jack Galt and the other plaintiffs here were entitled to attorney fees, and by the way, the takings issue was really decided. But they didn't say anything about exactly how they came to that conclusion, which always sort of left something up in the air about this. Then, believe it or not, in 1989, there was another case dealing with a brochure, an informational brochure that the Department of Fish, Wildlife, and Parks had put out, claiming that the brochure allowed the use of the bed and the banks, and that was an unconstitutional taking. Well, Judge Sherlock basically said, no, in Kern and Hildreth and in the Galt case, this was already resolved, and basically there's not a taking here through a brochure. But still, it always left something there about exactly, had the court really, really addressed this, that's the legal term, and that went to federal court later on in Graham, Madison v. Graham, over Stillwater River and some other rivers that were not navigable for tidal, but navigable for recreation under stream access statutes. And basically the argument there was a substantive due process violation under the 14th Amendment to the United States Constitution. Well, the court said, no, you can't do that. Basically, when you do that, we recognize, because there's textual provisions in the United States Constitution about takings, so we're going to treat this as a takings claim. And then they said, well, basically it was res judicata, and besides that, they were beyond the 3-year statute of limitations. What? Well, that went to the Ninth Circuit, and they basically said, if you basically claim that it's unconstitutional due process violation, you're stuck with that, and you didn't make a case, so we're dismissing it. The next final case was the Ruby River case in 2014, I believe, and now the judge there, the Supreme Court there, basically said the takings issue has already been resolved, but it went on to explain why that was so. It basically said landowners have a right to exclude people, but recreationists have a right to use the water and use the bed and the banks as part of that right to use the water. So basically, the landowner wasn't losing anything because they never had a right to keep people off the property who were floating and using the bed and banks. So that was the best we've got, and thanks to that court for basically telling us with some certainty that they actually did some analysis on this. From about 1987 to 1999, there were a number of bills that dealt with the regulation of rivers. And why I'm bringing this up is that if you're going to have an experience on rivers and people want to deal with crowding issues and other social concerns, then you have to have adequate authority in somebody like the Department of Fish, Wildlife, and Parks to regulate that. And the authority before this was only for public safety, public health, and protection of property. It wasn't comprehensive enough regulation to address these social concerns. So between 1988 and 1999, there was a series of bills to attempt to give the department the authority to regulate in a broader context and deal with all issues that people might want to have resolved on streams. Those all died until 1999, and the legislature chose to do its own regulation of the Beaverhead and Big Hole. Unfortunately, it probably wasn't the right forum, and the language was somewhat contradictory, ambiguous, murky when they came out with it, and besides, it put all of the burden of any limitations on non-residents, raising equal protection and privileges and immunities problems under the United States Constitution. There was, however, House Bill 626, and there were specific provisions in House Bill 626 that dealt with fishing, how close you could come to a fisherman in a boat, that sort of thing. And as the committee went through that, especially in the Senate Fish and Game Committee, they wanted to know what could we do to regulate like speed to a no-wake limit so you didn't bother fishermen as part of this social concerns. And in doing that, they realized they didn't have the authority to do that. And in those days, they would turn to the attorney for the Department of Fish, Wildlife, and Park and ask questions. They asked, well, what can we do about this? And I just said, add public welfare to the criteria and also protection of public resources. And they said, now you have the comprehensive authority to regulate rivers. And that was done. And it was, I have to tell you the story that at that time my director didn't want to have that authority. But I thought, I'm going to just suggest this because they asked me the question of what would work to do that. And it gave us the authority to do that and adopt regulations on the Beaverhead and Big Hole that limited outfitters to some degree and spread the use out throughout the river. Also, I think in the 2005 session, there was another bill there, House Bill 269, that basically provided for the fact that while you have a requirement that if you have a road that goes to public property, state or private road or county road that goes to public property, and you change that road, you have to, and don't allow that access anymore, you have to find a substitute. So we got that amended to do the same thing for streams and rivers. That is, when you change a county road bridge and have a new easement, you can't, very difficult to eliminate now public access because the statute requires you, when you've changed from one easement to another, you have to continue to have public access. The only other thing I can add here, and I'm sure I'm out of time now, basically is the two things I've left out have been bridge access, that we're going to go over that, and the Mitchell Slough case. The other thing is that what the department does, and has authority to limit on a case-by-case basis use of a stream where there's impacts on the aquatic or property involved with that stream. You can restrict and limit the uses They've had over a dozen of those and only had limits about 3 times. And then the other thing are the stories about portages and maybe, well, and portages that now the department simply works with the landowner and those work out without a formal process. The other is in terms of bridge access and what you do to make sure that the bridge doesn't impose a barrier. We're going to go over that some more, so we'll be able to tell a little bit more story. Did I come close enough?
You were so close. Perfect. So that wasn't even fair to ask him to do that in 10 minutes, was it? It's so good. So I really encourage you to read Bob's piece for great illustrations of some of those agency rules and those portage agreements that he was mentioning. A piece of the story that is, I think, a parallel story that is often overlooked in the story of stream access is the companion effort to create rights for in-stream flow, which would support our right to recreate on state waters. And to talk about that piece of the story, we have Chief Judge McEllier here, who in another life, before he was Chief Judge, worked on the stream access legislation and wanted to share that with us.
Thanks, Michelle. It's not because I'm a judge that I'm here. It's because of what I did before I became a judge. But it's fun to be here. And when I was talking to Michelle about coming, I got the sense very much that this was going to be a reunion of a bunch of guys and women with gray hair. And sure enough, that's true. And it's particularly fun to see my colleague, Mr. Lane, to my left, because since I've been in Montana, which is almost 3 decades, I've been applying for a sheep tag. And Bob and I have been litigating, or were, when I was an attorney, litigated against each other continuously, it seemed like. And after about 10 or 15 years of that, I approached Mr. Lane and I said, Bob, are you the reason I'm not getting a sheep tag in Montana? And he said, I can neither confirm nor deny. But anyway, my history with in-stream flow protection began as a law student in Colorado, and I had the privilege of studying under Wilkinson and Getches there, and that really ignited my interest in water. And I can't even remember how I got interested in in-stream flow, but anyway, I wrote a piece for the University of Colorado Law Review in 1989, arguing that private individuals should have a right to have in-stream flows just like public entities should, which then was kind of a radical concept. So I'm going to talk about that a little bit. And then I also participated in litigation over in-stream reservations and in the Mitchell Ditch case. So I'm going to call it the Mitchell Ditch, Bob.
In spite of the strict report.
Notwithstanding the ultimate result. So that's my background. With no further ado, I'll get into it. So in-stream flow protection from a legislative standpoint is one part of the panoply of protections that exist out there. And we'll begin with Murphy rights, which are really the earliest ones. They were named after a legislator named Murphy from northern Montana, northwest Montana. They were codified in, I think, 1969. They have 1970 priority dates. They were intended to protect blue ribbon streams. And, some of them, most of them are familiar. Madison, Gallatin, Middle Fork, South Fork of the Flathead, Yellowstone, Blackfoot, and several others. And that was kind of the first generation of protections for legislative protections for in-stream flows. Following that came the in-stream flow reservations process, again, another statutory mechanism. And I'm trying to think of who all in this room litigated those. Stan, you were there. That was in the old Supreme Court, at the state capitol, quite an august place to conduct a trial. It was pretty fun. Anyway, those in-stream flow protections have 1985 priority dates, and they're much broader than Murphy rights. They cover over 250 different reaches in the state of Montana. And they were intended for the use of the state and its political subdivisions or agencies and the United States. So pretty broad reach. And they were also for existing or future uses. So novel concept there. They were intended to maintain a minimum flow or level of water, but they could be used for other purposes. So conservation districts came in and made reservations of water for future irrigation purposes. They had a filing deadline. Objections to those applications were filed, much like happens in the water court today. The trial was had. Rights were recognized. They've got a couple other unique aspects to them that, in my opinion, dilute their efficacy. And those are that they got to be reviewed every 10 years or so to determine if the objectives of the reservations are being met. I'm not aware of any reductions in reservations, but maybe somebody in the room is. They can be revoked or modified, and they can be subordinated to new uses that are junior in time to the reservation. So kind of one hand giving and the other hand taken away when it comes to in-stream flow reservations. The next broad category, and now I'm kind of getting into territory that's maybe not directly intended to afford in-stream protections, but nevertheless does. And that next category is the formation of the Compact Commission, which was designed to negotiate and finalize claims for federal and Indian reserve water rights. So the effect of the Compact Commission, intended or not, was to create or recognize tribal and federal claims to all kinds of water, some of which included substantive water rights for in-stream flow. So an example of that would be the Crow Compact, on which I have worked as a judge, which set aside significant amounts of storage in Yellowtail to support in-stream flows in the Bighorn River. So there's one example. I think the Fort Peck Compact established flows in the Milk. I have worked on that's really distracting, Michelle, by the way. just kick me, okay? Okay. So there's tons of mechanisms via Compact, and those protections are, some of them are really significant. The interesting point there is that some of them are headwaters protections, and in my opinion, protection of headwaters in-stream flows is not where the issues typically arise. So not sure in general how valuable those are. FERC licenses, here's another one. So you'll see provisions in FERC licenses that are designed to support and maintain in-stream flows. That can include maintenance of water levels in reservoirs. It can include releases of waters from reservoirs to maintain base level flows in certain stream reaches. Various mechanisms there. Basin closure statutes is another one. And then finally, authorization of the state to purchase storage water. And I know the DNRC, I think, has authorization to do 1 million acre feet. I don't know how much they're actually doing. I know that FWP had bought water in Painted Rocks to support flows in Bitterroot. I think the amount there was 15,000 acre feet one time. Not sure if that's still in place. Bob's nodding yes. So there's a bunch of the mechanisms. So let's talk about how effective they are. I think there's a lot of problems with our structure to try to protect in-stream flows legislatively. The first and foremost of which is that the rights created by that legislation are simply too junior to be of any real value. So the depletions to stream flow are going to come from two causes: climate and diversions. That's the real source of the issue. And having a 1970 priority date isn't going to do much when you're at the back of the pack and there's many, many, many early rights that are for consumptive use ahead of you. So that's the principal problem. Sometimes those rights were sort of hastily assembled and not very well thought through. I think that was a valid criticism of some of the in-stream flow reservations. We had stream reaches where you created protections for more water than the creek ever actually flowed, and vice versa. And I think that was just a function of the time frame within which they had to be created. Um, and so, as a consequence of this, some dissatisfaction arose over whether something really valuable was getting done, and there was sort of a return to litigation or a litigation mindset. I think you guys, I just rolled in right before I got here, so I'm sure Mr. Getz talked about Illinois Central Railroad, all that other stuff, Mono Lake. I'll skip those things. Anyway, pressure began to arise or increase to use the public trust doctrine as a vehicle for creation and protection of in-stream flows. And the ag community where I was, most of my clients were ag related, so I represent the guys with the big hats. And their concern was that public trust doctrine was kind of a weaponized legal doctrine, and they were going to get rolled over, which was legitimate concern. I counseled the clients that I had to that effect. And so anyway, with a bunch of other folks, Stan Bradshaw, I don't know if Matt McKinney's here today, George Swan, we all kind of got together, this group of people with diverse interests, and said, you know what, we need to do better. In 1989, actually about the time I rolled into Montana, the legislature did create in-stream flow rights or authorized FWP to do in-stream flow leasing. And then the final piece was in 95 when Stan and I and Matt and some other guys kind of got all together and we said, we need to privatize this as well. And the thinking of that was that would allow surgical intervention to address particular reaches of critical habitat. And that was a pretty cool thing to get a piece of legislation like that enacted. And actually working with Bob and his team after that occurred, representing clients that had senior water rights, we negotiated leases with FWP. So, and the two that I remember were Hell's Creek on the Jefferson and Mill Creek on the Yellowstone, the trip of the Yellowstone. So the intention there was try to protect spawning habitat for fisheries. Anyway, that's kind of the, how am I doing? You stopped interrupting me, so I have no idea where I'm at. Okay. Well, we'll finish up ahead of time. So to summarize here, there are a ton of protections with the benefit of some time in this profession. My conclusion is that the best solutions are the ones that are specifically targeted as opposed to general in scope. And so I think that some real good was done by authorizing FWP to do in-stream flow leases and by authorizing private parties to do the same. And I'm a fan of the latter because, you know, towards the end of my career as an attorney, I ended up representing people that had the motivation, the land, the water, and importantly, the money to effectuate change on the ground. And so to me, that's the measure of success when we're talking about policy things like this is, what did you actually get done to help a particular river or stream, as opposed to a concept adoption of a concept which may not itself translate into translate into something positive on the ground. So there you go. That's the background on in-stream flow legislation. Thank you, Michelle.
Thank you, Judge. Of course, one of the benefits of that last legislation, which I think took a few tries to get passed, is my memory, is that then we can have a senior water right that suddenly becomes dedicated to stream flow. Bob and Mark, would you add anything to the stream flow story?
I will too, but go ahead.
Judge McElroy is absolutely right. One of the problems with in-stream reservations at this late date is the late priority date. It has limited effectiveness in terms of really making water available for a stream or river. And I was always told by the biologists If you dewater a river, it's going to take 7 years for that trout fishery to come back. So you can see how significant it would be if we had a little bit different scheme for in-stream rights. I've always felt if we could invert things and do it differently, you'd have a minimum survival flows for the fishery as a baseline by which all other rights came after that, without really affecting very much those irrigation rights, because at that level it's hard to get water in your ditch anyway. And that brings to mind what Judge McEllier was saying about the leasing program and how valuable that is, because what happens with the leasing program are on small tributaries where you can lease with a willing landowner a right that's senior enough to keep water in there throughout the year, throughout the spawning season, and throughout the incubation and return to the river for those fisheries. And that's been done because that is that sort of specific thing that Judge McEllier was talking about, where you can focus the leased rights to get the benefit out of them that you really need. Thank you.
I was just going to make a couple of points, but I can't help myself in making a third here. And I'm going to clearly distinguish myself between my two counterparts up here. And I'm going to tell just a quick story about how I won't either confirm nor deny, but I may have been trying to impress a girl, and she was asking me, she was like, so what do you do? And I was trying to explain it. And this is right when TUV DNRC was a really hot topic, and also the bridge access bill was. And so I explained that, I was working to, make sure that groundwater and surface water were connected, and also to make sure that two overlapping rights of ways constituted an opportunity for public access. And I think I really impressed her by those two very basic things being so complicated. But so that's one point. The other point is that I think that throughout all of this, there's no doubt that the recreating public has been really engaged on the stream access and bridge access issues. It's been have so much influence put upon the legislature by the citizens of Montana has really made a huge difference in how we have reacted to the stream access laws in general. That hasn't always been the case with the in-stream flow issues. I think that as important as they are, we don't have nearly the same kind of public interest as in the case of the in-stream flow legislation, there was no doubt there was lots of people involved there. But other than that, there just hasn't been nearly the same interest. And then my only final point is just I think that whether it is we're talking again about stream access, bridge access, or all of the water law statutes, they're extraordinarily fragile and complicated. And I think that one thing that's very clear, and Judge McEllier hit on this, is that you start, you got your ball of yarn and you start pulling on a thread, and if legislators that may not have a lot of knowledge about these issues, they start pulling on these strands of threads, and it just gets really complicated really quick, and they really don't know what the unintended consequences are. So I think it's critical that we look at these things very carefully as we move forward into the future.
Mark, I'm going to ask you to keep talking and shift us over to bridge access and your work on the bridge access bill.
Great.
And part of the theme of today, of course, is lessons. So if you want to hit a few lessons, we'd love to hear those. Thank you.
Well, I think that first off, I just do want to say that this is an extraordinarily important conversation to keep having. I think it's fantastic that we're doing this, and I really I think about the Newton quote just about standing on the shoulders of giants, and whether it's from the perspective of all the people that were on the panel earlier today, there's no doubt there are some huge giants that were standing there, or that were standing on their shoulders. But also, I don't work at Montana Trout Unlimited any longer, but when I did, it was just so incredible to be able to work with those folks, and they're still working on stream access. It's an absolutely critical component of what they do, and I think it's really, really important that we have watchdogs out there that are making sure that our stream access is really well protected, and they are certainly an organization that does that. So Mr. Lane's overview was great. I'm not going to do the same justice to the bridge access as he did, but I'm just going to go through and hit a couple of high points on the way up to kind of the story of success moving forward. So it really started in the mid 90s. The challenges were emerging in southwest Montana, and there was this big consideration about whether or not the public had the right to use the road right of way to access the stream. And that quickly led to provide clarity for both landowners and folks that wanted to recreate. Fish, Wildlife, and Parks in Madison County requested a formal Attorney General's opinion on the matter. And so that occurred, that we finally got the opinion in June of 2000. Bob was extraordinarily influential in that process, but it was an Attorney General that came out from Joe Mazurek. And so instead of kind of going through the specific provisions of the Attorney General's opinion, I'm just going to kind of continue to fast forward here and really get to the point where we were trying to work on the work to codify the Attorney General's opinion, or to codify the opportunity to basically fence to bridge abutments. And so between 2000 and 2005, there was an era of real overreach by legislators, and each side was bringing bills that, from my perspective, were just really asking for too much, and I was involved in that process. So either the bills the goal of the bills was really just to put fences to bridges, or it was just to create too much access with very limited allowances for landowners. And if any one of those half dozen or so bills would have passed that occurred between 1999 and 2005, in my opinion, I don't know that we would have really achieved this kind of durable, long-lasting solution to the problem. The bar was simply pushed out too far, and in retrospect, I'm glad they all died. And part of the reason that I'm glad they all died is because after the 2005 session, between the 05 and 07 sessions, there was this swirling controversy. This was clearly becoming an issue that was going to be at the legislature time and time again. And I convinced myself with some other folks that I worked with that we could solve this problem. So I set to work. I talked to a few people, again, trying to stand on the shoulders of giants. I didn't talk to too many people, though, and I don't want to brag, but I wrote the perfect bridge access piece of legislation, and it was incredible, you guys. It dealt with liability issues. It had exact locations for access points. It had direct involvement for the counties. It had the bill required fences to be inspected and then permitted. It dealt with costs of fences, who pays for them, potential reimbursement. I even had arbitration panels in there. I mean, this bill was awesome. And I know it'll shock everybody here, but that bill didn't pass. Not only did it not pass, but the very first committee it hit, they struck the entirety of the bill after the title and tried to rewrite it from there. And that one got killed also. So it was a great experience for me. And the only benefit of that bill in retrospect was that there was some serious lessons learned. And one is that a complex bill that was going to solve all of the problems that everybody saw was just simply not going to work. And it sounds so obvious now, but at the time we really did feel like we had to try to solve everybody's problems along the way. The second lesson is that lawyers and legislators love to squabble, so it was really up to the lobbyists to fix the problem. So I just want to say, like, it's kind of the lobbyists are the unsung heroes here, so I just have to make that point. So as crazy as that bill was, it did get super close. It only ended up dying by a few votes on the House floor. And I just want to back up one quick step here and kind of identify, this is what we did after the 2005 session, is we really tried to just very specifically identify what the specific issues were that we needed to solve. So one of them was, under Montana code, all highway encroachments were illegal and needed to be removed, meaning ranchers across the state of Montana had serious problems when it came to livestock control in and around bridges and rivers. And so that was one issue that the Stock Growers Farm Bureau, other landowner groups were very interested in solving. The other one is that Montanans really, I think clearly wanted to ensure that they had their historical recreational access to rivers and streams from these road rights of ways. And so the third, this wasn't immediately one of the big issues, but it became one of the big issues, was that counties were terrified of dealing with this issue at all. And they really didn't want to deal with it. They just wanted to stick their head in their sand, but they knew that they were going to have to, especially after my brilliant piece of legislation in 2005. And so what they really didn't want to deal with is they didn't want to deal with the liability associated with either the access points or the encroachments of these fences. And so in the waning days of the 2005 session, or excuse me, the 2007 session, we were able to get some dialogue going, because I think that some of the landowner groups were starting to recognize that they weren't going to be able to fight this issue the same way they had over and over. And so we worked with landowner groups, the agricultural groups, Stock Growers Farm Bureau primarily, local governments in the form of MACO, and then a couple of sportsmen's organizations. And Fish, Wildlife, and Parks convened these negotiations. And we set some ground rules for how those negotiations were going to occur, and those ground rules ended up becoming really important throughout the interim. And discussions then progressed, and we worked really hard to try to figure out, keeping our eye on the ball, staying really as focused as we possibly could. And over time, we eventually hammered out a compromise. And I remember one of the great points was that the stock growers, who were a pretty active partner in this negotiation, they were having their annual meeting, and they said, well, we need to discuss this at our annual meeting, but we're not going to be the ones that are going to present this. Mark, you have to come and present this to the stock growers. So that was a moment of truth, and it was interesting to hear what the stock growers had to say about it. And their president followed me out into the parking lot afterwards, and he basically said, it's nice that you're trying to do this and all, but it's never going to happen. And so we were able to get to the right before the 2009 session. We had what we considered to be a final bill, and we had Stock Grower support, Farm Bureau support, MACO support, and then a number of other organizations, sportsmen, and other groups that were involved as well. So how am I doing? Close? All right. Give me a couple more secs here. And I think importantly, though, as we were putting the finishing touches on the bill, the district court decision came out. Basically, Judge Lauren Tucker ruled on summary judgment against the Ruby River Valley landowner who intervened on the behalf of Madison County. And I think this is an important place to really kind of point out how important the Public Land Water Access Association has been in all of these issues throughout Montana's history on stream access, because they have been the kind of litigation arm for access, and they've done an incredible job. And what that summary judgment told us is that we were absolutely on the right track with our piece of legislation going into the 2009 session. And so you all can read the bill, but what it ended up allowing for, by the time it was all said and done, is that it allowed landowners to construct fences to bridges, really important point for them. It said that fencing couldn't unduly restrict public access, and the stream must allow, or the access must allow for public passage. The fence must allow for public passage to surface waters. It allowed for construction of features that both accommodate access and livestock, so stiles, gates, walkovers, etc. And so we had a lot of conversation about starting the bill in the House, moving it over to the Senate, which is exactly what we did. We started the bill in the House, and when we moved it over to the Senate said, oh my gosh, we got to fix this bill. And so the way they fixed the bill is they added to our list of stiles, gates, walkovers, etc., they added wood rail fences, and that fixed the bill. So I'm glad that was all they did. And then it also established a very simple process to settle issues regarding kind of intractable conflict if it arose. And then finally, it did all of this without increasing liability for landowners. It actually reduced liability for landowners and didn't increase liability for counties. The bill passed with huge majorities by the time it was said and done. And Representative Kendall Van Dyke was the guy that carried the bill, and he was instrumental to its passage and its success. I think that as we go through these legislative processes, it's so critical to understand who sponsors are going to be that are going to be really important to help you get done what you need to get done. But yeah, Kendall was huge in the process. And then I have a couple final notes, but if I'm done, do you want me to do a couple quick final notes? All right. So, so a couple of final notes. I think that, again, what the Public Land Access Water Association did is they made it was clear to them, and it was clear to everybody else that this wasn't really just an imagined issue. I mean, I think that there are some stream access issues or issues in general that are just kind of imagined issues, and this was a real world issue that arose out of razor wire electric fences, and to be fair, it was also born out of the fear of just unfettered access. And so, I really do think that we did help carefully solve a problem to the issue, and it's worked. And then, so the only way we were successful, much like the stream access bill, is that it only worked when we really did just sit down and get to the nut of exactly what the issues were. And Montana Trout Unlimited had a clear position and a clear perspective, but it wasn't going to really go anywhere without talking to the Stock Growers and Farm Bureau. And sometimes we had to drag them kicking and screaming, but we did. And then the final important point here, I think, is just that, again, the public engaged on this issue. I mean, not just Butte was important, but everywhere across the state of Montana was critical to the passage of this bill. So I really hope that this is a success story, and I really hope people see it as one. And I think it's survived the test of time so far, and I hope it continues to do so.
Bob and Chief Judge Malclier, would you like to add your thoughts on the bridge rules and how they've evolved?
I guess I'm sort of the guy to summarize some stuff in the sort of boring, trivial details, but bridge access involved a county ordinance that was later withdrawn, an AG's opinion, 10 bills before the legislature before it passed, and then a final concluding decision over the Ruby River and access at prescriptive road easements. One thing that this highlights here is how important it is for both sides to get together and find common ground and set benchmarks and how they engage in this to come to a solution, and how important the public has been in this with supporters of stream access by being involved in it. That's made a really significant difference. One final comment on this. Here is one way of looking at this issue, and it seems pretty simple, but not that easy to solve. The idea is these bridges, these fences that landowners have to control livestock, the easiest way to do that at a bridge is to build your front bridge or fence to the bridge abutment. In doing that, that's illegal as an encroachment on the right-of-way. On the other hand, if you follow the road right-of-way and go straight across the stream, you've got a fence now that's probably going to get blown out every spring runoff, and one that's a real hazard to recreationists in floating. So this is a story that Marcus pointed out became a win-win situation here after a lot of work. And sometimes these things just need that work and cooperation.
Just one brief thought, not specific to the bridges issue, but just an observation as a judge now, and that is that I think when it comes to resolution of these sweeping public policy considerations, negotiation and consensus building is by far the better alternative to litigation. And I say that because when you litigate a case, you're going to turn it over to a stranger like me and expect a comprehensive decision that addresses all the issues. And that's just not realistic. So far better to do what these gentlemen just described, and that is lead a discussion than lead a fight.
you one follow-up for Mark. How did you turn the stock growers around from that parking lot conversation where they said, "Dream on, boy"?
Well, so I mean, I guess to be fair here, the stock growers were going through that interim. They were absolutely working in good faith, trying to get to the point where they could agree to this legislation. And they felt, I mean, they had given enough support that we were able to put their name on different fact sheets, et cetera, going into the session. But as the session wore on, they decided to pull their names off. And it wasn't until the last floor debate in the Senate where Senator Debbie Barrett, who has long been an anti-access person, she stood up and I had no idea she was going to do this, but she stood up and actually supported the bill, which led to I don't know what it was, a 46-3 vote on the Senate floor. So they were there, and then they weren't. I wish I would have made the same deal that Ron Waterman made, which is like, we're going to stick to it and we're going to stick together. That would have been smarter to do it that way. But yeah, we worked hard to keep it all together.
Well, my memory of the Kennedy bridge decision, which I like to call the Bridges of Madison County decision. It's just more fun. Is having the privilege of introducing the oral argument to the audience. It was heard at MSU, and walking into the building with protesters and signs and ranchers all over in the audience and anglers all over in the audience, and seeing the level of interest and engagement was really extraordinary. And it tackled the difficult question of what if there's nothing in writing to describe the right-of-way for the bridge, and we are relying only on prescription. And I called Justice Wheat, who authored the opinion, and he couldn't be here, he's out of state, but I asked him about his memory, and he said he thought the most important part of the decision is that once the court recognizes a public prescriptive easement, the public can exercise the use for a variety of things. They're not limited to one particular use that happened at one particular point in time. So that was a very important decision in his mind, and he wanted to pass that story along. Our final topic is going to be the Mitchell Slough, and it's a very non-controversial topic, even among the panel. We gotta have a little controversy today. We can't all agree about everything. So we're going to do one final deep dive into what waters are capable of recreation. And the Mitchell Slough decision attempted to address that. And Bob is going to give us some more of that story, but I know that the other two panelists also have thoughts. So thank you.
I entered this discussion with a little bit of trepidation with Judge McEllier sitting beside me, who is on the other side of litigation over Mitchell Slough. And the only way I can sort of bridge this gap is saying, and giving a caveat and saying, this is my opinion about what was important and what happened. So we may have two stories, and it may certainly deserve two stories. From my view, this is simply an issue of whether a side channel of the Bitterroot River that had been a side channel essentially forever could somehow become a ditch. Let me give you some facts, then let me give you, yeah.
Already getting looks from the audience.
Hey, Bob, isn't it true that whoever gets to frame the question determines the answer?
Well, and you'll have your chance. I'm going to give you a few facts and then give you a little bit of the procedure and then tell you what the Supreme Court thought about all of this. First, in 1872, there was a public land office survey. That's what they did in those days, surveyed the new territorial land. And they came across what they called the right fork or the St. Mary's Fork of the Bitterroot River, which is essentially in the same location as the Mitchell Slough is now. Now, The river there, the Bitterroot River, has a main channel, and then it divides into an east channel, and then off of that comes the Mitchell Slough. Although in about 1995, the landowners decided that they should start calling it the Middle Ditch, and they were real consistent in that. The rest of it called the Mitchell Slough. I don't think it was really a Mitchell Slough. But in 1871, the Edna Ditch attached its head gate to the Mitchell Slough. They were irrigating on the east side of the river. That was the nearest part of the river, so that's where you attach your head gate to in those days and start your ditch. The Edna Ditch, the Union Ditch came in 1889, and the Webfoot Ditch came in about 1871, all in about the same place on Mitchell Slough, about a third of the way down of the 15-mile route of the Mitchell Slough. In 1915, they built a concrete diversion there at the confluence with the Mitchell Slough and the East Fork of the Bitterroot River. Then in 1940, they moved that confluence up about a quarter of a mile to what is now the Tucker Head Gate and reconnected the Tucker Head Gate to the rest of the Mitchell Slough to continue the Mitchell Slough. Now the Mitchell Slough, of course, was altered then for that quarter of a mile to get it connected back, connected back to its route. It had been further altered along its route to protect land from erosion, to keep the water and the river close to the head gates, so they didn't have to change the head gates. And in an analysis of the flows in February of 2001, they found that the USGS found that there was about 18 CFS leaving the East Fork into the Mitchell Slough, even though the head gate there at Tucker Head Gate was closed, and the Mitchell Slough gained another 40 CFS in its route down to its confluence with the Bitterroot. This river is, Mitchell Slough is east of Hamilton and Stevensville. The procedure was that landowners along the Mitchell Slough had decided that it wasn't a stream under either the Natural Streambed and Land Preservation Act, and they didn't have to get permits. I think this is a surrogate for what they really wanted was to have it found as not a stream or a branch of the river for stream access. So that started with the Bitterroot Conservation District. The Bitterroot Protective Association and the department opposed that and asserted that it should be a stream for the 310 permit under the Natural Streambed Land Preservation Act. And there is a declaratory ruling held by the Conservation District. They decided that it was not a qualifying stream for a 310 permit. And then came the decision whether that should be appealed. The Bitterroot River Protective Association appealed it to the district court. And at that time, Governor Martz decided that that was a local issue and the department was not allowed to appeal that. Well, the Bitterroot Protective Association moved to make us involuntary plaintiff in the case, and I was requested to write a brief saying why we should be an involuntary plaintiff. Well, by the time that issue came up before the district court and Judge Meisner in January of, that would have been, what, 2001 maybe? But I've got the dates right. Anyway, now is Governor Schweitzer was the governor. And Governor Schweitzer apparently had not gotten along real well with one of the landowners, so he said, I want you guys to be involved in Fish, Life and Parks. So I was able to tell the judge, you know, I had a client previously, it said that client did not want us to be involved in this, but I've got a new client now, Governor Schweitzer, and he says we should be involved in it. Forget that brief I filed, we want to be in it, and we were allowed to be in it as a plaintiff. And in the process here, it became more than just a 310 issue. It became an issue about stream access because the Bitter River Protective Association basically asserted in their appeal that it was a stream under stream access. And then some of the landowners counterclaimed saying it was a stream, not a stream under the stream access. Um, I'm going to add one other thing, and I hope this is accurate, but Judge McElhinney may have a little bit different opinion on this. But the quarter mile from the Tucker Head Gate to the reconnection was constructed. And a stream morphologist for the landowners, and a stream morphologist looks at the lay of the land and flow in a river and decides how that river should meander based on those two constraints. Well, the study that this expert did was on the constructed part of the quarter mile, and he decided that looked not like a stream, but like a ditch. Well, that made a lot of sense because it was, at that point, a man-made connection. The Supreme Court looked at this and said, here are the issues. Is this a natural water body under the stream access statutes? Is it capable of recreational use? And it is not diverted from the river by man-made conveyance system. And they said a dictionary definition of pristine waters as natural waters as being pristine just is an absurdity in Montana. That this doesn't work because most of the rivers have a significant amount of their waters once were touched by man and are now flowing in it. And part of the argument by the landowners was basically you could discount any water that had once been diverted by man and was now returning to the Mitchell Slough because those weren't natural waters. They had to be discounted. The Supreme Court said, no, that's a water course, and the waters flowing in it form part of a natural water course and can be subject to further appropriation. The other argument here was basically because all of the modifications had been done to the Mitchell Slough, it was no longer a natural water body, and therefore it didn't qualify under the stream access statutes. The court said basically, yes, it was man-altered, but not man-constructed, and determined that it was a natural water course subject to the stream access law. And said basically that construction hasn't altered its natural character as a stream, and also basically relied on the 1872 General Land Office survey as showing this had been part of the river and now remained part of the river, continued to be part of the river, and their stream access could be, it was available as stream access. One other issue in particular I think should be noted is you can probably make an argument that, well, this is a pretty unique situation, that this is a one and only unique case. But I argue, and we did a little bit of look at this in the department, is there were a number of other side channels in which landowners had basically, at the start of the side channel, would put up a diversion to help control the flows, and then have another ditch coming off of that for irrigating their land. This was not an uncommon practice, so it affected a lot of those. One other thing here happened, as you might imagine, and perhaps from our story about how a stream access bill was treated, and that is that there are always some ways in which you can try and minimize or undermine a decision like this. In 2009, there was Senate Bill 314 that would exempt smaller Class 2 streams if they were altered by humans and you could not count their return flows. And note in the Bitterroot River, as it flows in the summer irrigation season, during that irrigation season, 3 times as much water is taken out of there in flow rate as there flows in the river. So you can pretty much sort of start counting in that sort of a theoretical sense. If those return flows don't count, maybe theoretically there isn't any water in there anymore, even though you stand out there and look at it and fish in it, there's plenty of water. That bill would have basically enacted the arguments made by the landowners who opposed Mitchell Slough as being considered still a side channel of the Bitterroot River. The sponsor of that, Senator Leibel, I don't think he knew what he was getting into when he introduced this bill. There was a lot of opposition to it. And what he did was something I'll always respect him for. He got together both sides, talked to both sides, went through all of the arguments, understood what was going on here, and then wrote the committee and said, I don't want a hearing on my bill. And that was a way a sponsor could withdraw a bill from consideration. In 2011, in House Bill 309, again, that would have basically said, if you put a control structure on part of the stream, a side channel, and if return flows constitute a majority of the flow, then that's no longer a stream. Now, this bill was written in a way that was about as confusing in language, as murky in language as you can possibly imagine. And one of the things that helped with this is if you had gone through the Mitchell Slough litigation, then you understood what they were getting at with this language. Otherwise, it was pretty hard. Time's up. It was pretty hard to figure out what in the heck this bill was about. When we figured it out, Mark and TU and others let everybody know, and the hearing in the Senate Agriculture Committee had 300 people show up for the hearing, which is an enormous amount for a hearing in the legislature. 100 people testified on the bill, and when the committee took up the bill, they tabled it by one vote. So that gives you an example of how important not only public is, but how important it is to be vigilant if you're a stream access supporter. That's my story, and I think I'm going to stick to it.
Bob, you're going to be shocked, but I'm not going to disagree with a thing that you said.
Could you repeat that?
First time ever. My comments are more anecdotal, and that case was the last trial that I had as an attorney, actually, before I went off and did other things. And it was as much fun as you can possibly have as an attorney, I have to say. And it was because of a combination of things. First, the passions on both sides and the convictions were deep and heartfelt, and it was a true battle of conflicting points of view, of different cultures. The attorneys all the way around were outstanding and truly worthy adversaries. We had a lot of scientific and engineering and hydrological evidence and testimony, so tons of really interesting experts. So that was the first time I think I ever ran into a paleometeorologist who was never heard of that before. Really, somebody who can reconstruct climate hundreds or thousands or even millions of years ago. So really, it was really, really fun. And it was, we were up till 2:00 every morning prepping for the next day, and there were TV cameras in the courtroom every day. And, it was an exhilarating case to try. And I really enjoyed it. And I have fond memories of being there with Bob. And for all of you law students in the room, I hope that that's the kind of opportunity that you get in your career going forward, because it was a magnificent thing. I will say that going into the trial, even before we tried it, here was my cast, easily said now with the benefit of hindsight, but I was pretty confident we were going to win at trial. and I was pretty confident we were going to get blown out on appeal. And that's pretty much what happened. And so that was one recollection that I had. Another was how gracious Judge Meisner was. And I think that was my third case in front of Judge Meisner. And he was one of the guys that you'd try a case in front of, and you could never tell what he was thinking, so he must have been a great poker player. But he was really kind to all the attorneys and patient, and I made it a resolution of mine to try to model myself as a judge in part after him. So that has some specific meaning to me. And then one word of caution to you attorneys, if the judge ever adopts your findings verbatim, you should be worried. I mean, your initial reaction there is going to be, oh, cool, big sweep at trial. But that turned out to be a bad thing on appeal. And then the other thing that when his order came out, he adopted a standard which basically went as follows. I'll paraphrase slightly, but it's not natural if the hand of man is somehow involved. And I just thought, oh, heck, we're toast on appeal. Anyway, I think a month after that trial was concluded, I went off, quit being a lawyer, and did other stuff, and Mr. Waterman took over the appeal, and the rest is history. But it was a great case to be a part of. It was a real privilege and honor to be on any side in a case like that, and have fond memories. So thanks, Bob. Yeah.
The only thing I just want to kind of reiterate one point is just the critical nature of having people show up. I mean, again, once we got to, through the litigation, House Bill 309 in the 2011 session, I mean, without the right people showing up, it made just such a huge difference in that particular bill. The other point that I feel like I just have to make here is that over the years, I mean, since I started being a lobbyist in the Montana legislature, it was absolutely essential to have somebody, in my case, it was Bob Lane, who could always identify and get to the most critical points of whatever pieces of legislation were out there. So being able to rely on him to identify this what was a pretty murky piece of legislation, but then understand how it was going to really affect all of the streams and rivers across the entire state of Montana was critical. So always have a good lawyer at your back is my point there. So.
Just one more comment. First, I want to recognize Becky Doctor, who is another attorney involved on our side of this. And second, to just basically say, no surprise, Judge McEllier, but I agree with everything you said there. And just a word of sort of, it's not a warning, but it's just a word of advice to new attorneys. You don't get many cases like that. Treasure them. And when you have opponents like we did, Judge McEllier and others, treasure all of that. And for Judge Meisner, he set that case up for us on appeal. I agree with that by saying, well, you can alter it out of its status. And besides that, return flows don't count. And I thought, those are basically questions of law. We've got a heck of a chance here now. And so that happened.
I wanted to give all of you a chance to talk to these three amazing individuals who did work on this, on the subsequent developments in stream access law. What questions do you have? I apologize, our portable mics are, you might as well just yell. I think we've thrown in the towel on our portable mics, but please ask your questions. And maybe Ron has thoughts too, as the appellate lawyer. Ron says I should quit giving him work.
I enjoyed the stuff on the bridge access, but what I want to reiterate is the fact that you could work with the stockbrokers and all these other people, but when you get a billionaire like Kennedy coming in who disregards everything, that's where our groups have to stick together. And one good example of how selfish he was at the Supreme Court trial in Bozeman, his attorney got up and said, we own the bank, the beds of the river, the water of the river, and the air above the river. And the whole place just groaned.
What's the source of the in-stream leasing funding? Do you know, and do you have any sense of what kind of security there is in that funding going forward?
I suppose that's directed to me, so I'm going to redirect it to Bill Shank here. He raised his hand. He's with the department. I don't remember what the funding was. I think I once knew.
Trout Unlimited.
The primary source of funding is something called the Future Fisheries. Well, there's a Future Fisheries Fund. It's licensed dollars. We're giving spending authority. It's allocated by the legislature. And those are monies that we tap. We can apply for. Our fisheries pilots apply for that for in-stream flows, but also habitat projects, etc. And then I'm sure Mark can address on, or Stan perhaps.
Yeah, let's pass it over to Stan.
Yeah, some of the private or nonprofit.
And we have Carter.
Yeah, so, I mean, Trout Unlimited, we walk around our pockets full of money. So I called Bruce Farley when he was there and said, Bruce, can you cut me a check for $100,000 to make sure? But the reality is, every time that you fund a lease, the funders, whether it's Future Fisheries Fund, which is a huge source for both the Clark Fork Coalition and that, or others, and west of the divide, the Clark Fork Coalition and Trout Unlimited are lucky to have access to a fund out of the Bonneville Power Administration called the Columbia Basin Water Transaction Program. But every funder wants to know that there are other funders with skin in the game. And so every time you go out to seek funds for a lease, you're going to have to go to at least two sources, and the more sources, the better, because everybody wants to know that they're not the only one in the game, because it's sort of an indicator as to the breadth of the interest in that particular lease. And so every time we do a lease, while we're working on the lease and the change applications and everything else, we're running around like crazy trying to find money to fund it.
Then how long do they typically last? I mean, are they yearly or?
So the way the statute reads, for all but a very limited piece of fish, wildlife, and parks opportunity, if you just do a basic lease that doesn't involve any sort of infrastructure, what we call conservation infrastructure, it's up to 10 years. It may be anything less, but the DNRC process is such a pain in the ass that if you're going to do it, you better do it for more than a couple of years. But beyond that point, once you get your 10 years, if you want to renew, you can renew for another 10 years into perpetuity, depending on the willingness of the landowner. If there's some sort of irrigation infrastructure that is saving water, whether it's piping or sprinklers or whatever else, you can go for a lease for up to 30 years to sort of account for the depreciation of that. Once you hit the end of that 30 years, if you want to renew it, you can only renew it in 10-year increments. Now, the one exception to this is the limited exception was that Bob, back in 2009, got a bill passed, I think it was 2007, got a bill passed as part of their leasing authorization, which is sunsetted every 10 years or so, to allow them to do on up to 12 stream reaches a permanent transaction to in-stream flows, an actual transfer of that water right permanently to in-stream flows. And Bill, I don't know if to date, have there been any done?
No, but we've got more than one in the works now. That are in front of the NRC for the change process.
Now that's really critical because that bill sunsets in 2019. And as Bill knows, I've been ragging on the department for some time about this to get something done. Because my fear is that in this current legislative climate, if you go back to the 2019 legislature, if you haven't done any of these, you're not going to get that renewed. So anyways, those are the sort of opportunities you have to transfer water to in-stream flow in the leasing statutes.
Question on that. Is there a water right there, or money plays out, in-stream flows in?
I mean, if there's insufficient funds to continue making the lease payment?
Yeah,
You can't get the money,
yeah.
and the lease isn't continued, what happens to the?
Oh, okay, so I can answer that. So, the answer to that is the way the statute is expressed to us is after your time in the legislature, obviously. At the end of the lease, if the lease isn't renewed, the water right automatically reverts back to its original purpose. And that was put in because the irrigators were scared to death that once they made this change, if they changed their mind at the end of the lease, they were going to have to go back through what we now know as the Byzantine process. And so it automatically reverts.
Goes back to irrigation or.
Yeah, or whatever it was they were doing before they had to change it. So our big challenge is to try to get them to keep it.
To get a follow-up question, Judge, you mentioned something about the 1985 allocations. Could you explain that a little bit more? What is in place of the present?
I think you're probably referring to the in-stream flow reservations. Is that the gist of your question? I can't remember all the stream reaches. It would be most of the, they were kind of divided by basins or large basins. So there was, Yellowstone was a separate category, Upper Missouri was a separate category, Lower Missouri was a separate category. My recollection was that the deadline for filing those reservation applications was not the same, but pretty close in time. And the gist of it was, put in the app, you can set aside water for existing or future use, and part of that included set-asides for in-stream flow purposes. Those have had a pretty significant effect, in my opinion, not because they necessarily protect in-stream flows, and that goes back to the priority date issue, but because of the leverage that they offer holders in negotiations when you're in the midst of trying to get a new permit or prosecute a change application. So in other words, Bob and I and other members of Bob's team often had negotiations when I was representing clients seeking permission, looking for a change approval on stream reaches where FWP had in-stream reservation. So in that respect, they were highly significant, not as significant because of the
That relates to the Yellowstone River that the legislature spent hours trying to figure out and actually came up with some in-stream law.
I'm not sure I understand that question. I would yield if somebody else could pick up the answer to that.
Well, the legislature set up the process for these reservations.
A specific allocation in the Yellowstone River. We came up with
Are you talking about the Murphy rights?
no,
Okay, all right.
It was about that time in the mid-80s. We spent hours going through the Yellowstone River, where we never did any other river. What we did, we set aside for municipal use, in-stream use, all the other uses were all allocated.
I wonder if it got folded into the general reservation stuff.
Stan's raised. Stan's got, here we go. Go, Stan.
The 73 Water Use Act provided the language that would allow for reservations. And the Yellowstone reservation is done under the auspices of that act, as was the Missouri. And so that's still in place. And as Judge Bagley pointed out, it doesn't get used as much now, I think, because it's a pretty clunky tool to work with to start with, and then back into what you have is as much as you like. But that was the source of the authority to do Yellowstone.
Michelle?
The Yellowstone, Upper Missouri, Lower Missouri, Little Missouri, all of those are under the reservation system, which is basically sort of a planning document about allocating water to ag, municipalities and others for in-stream rights. Once those orders are signed, those rights are established, and they cover about 70% of the state. One other comment here on the water leasing, and adding to that, the department could acquire an irrigation right in fee and change that to an in-stream use in fee. The opposition to that was basically, well, If we do this, the department's going to get all of the water. You just watch them. They're going to get all of the water. Now, and Stan's point is right on point, that if we don't have some of those that have actually been accomplished, they're going to say, we gave you this and you didn't do anything with it. So that sort of shows you to the nature of this. You have to be vigilant. You have to keep working on these things.
Just to comment on the Mitchell Slough. 2004, Brian Schweitzer got elected governor, and I was no longer a legislator, and I went to work for him as chief policy officer. Brian has always been extremely interested in stream access. Now, I don't want you going away thinking that Brian made a decision on Mitchell Slough because he knew somebody down there, because as far as I'm concerned, he didn't know anybody. He and I went down, we flew into Stevensville, Huey Lewis picked us up in his old Lincoln with hay in the back, he had jeans on, and we went up to the Tucker head gate up there, and we met with the people up there. And there were some interesting people up there. There was some jewelry that I can tell you could have been used for riprap. And then after that, we went down closer to Stevensville and met with the anglers and for people that want to use the river. And that was quite an animated little meeting down there. We came back and Brian said, put Fish and Game back on the case. And that's when Bob Williams got loose.
So we're about to take our last break, have our last panel, and then the governor's coming in to close everything for us before we go party and do an Irish sing-along. This is a true one in honor of all the beautiful stories today. I think it's only fitting. So come join me in thanking these gentlemen. And in this final panel, I am joined by two amazing colleagues and friends who also work in the world of water and look at it from very different directions. And one of those colleagues is Professor Brian Chaffin, who's from the School of Forestry and Conservation, and he is their water policy professor, and he looks at things through non-lawyer lenses. I told him he is our breath of fresh air at the end of the day. And he's going to bring economics and other social analyses and science-based analyses to this question of what might lie ahead when we try to continue using waters for recreational purposes in light of changing water conditions. And then I'm going to talk very briefly. I'm actually going to take us into that question of how do we work with water rights and stream access and the public trust together, which I think is a delicate question. I'm going to try to touch it without poking myself too hard. And then Professor Monty Mills teaches with me at the law school, and he teaches Indian law and Native American natural resources law. And he's going to talk about tribal water and the possibilities for co-management for recreational uses there. So I'm really pleased to have them with me. We're the young Ivory Tower team, as opposed to the early old-timer team. So, but we all like to get our hands dirty, so I think we won't be too Ivory Tower. We'll see how we do. So without further ado, I'm going to let Brian get started.
Does this work now? All right. Thank you, Michelle. Thanks so much for organizing this, to everybody who put this on. It's an honor to be here. And like Michelle said, I come from a little bit of a different perspective, but I'm really happy to have the opportunity to bring that here today. So without further ado, excuse me. Can everybody hear me? Oh, okay. All right. That?
All right.
Threw it in. Sorry. All right. So that's everybody's worst nightmare, right? That we tangle it up and everything. But I really appreciate the opportunity to be here. And without further ado, I want to start with 2 points that are connected to stream access and maybe not as explicitly as some of the points that we've talked about today. But the idea that stream access is implicitly linked to Montana's recreation economy is the first thing I want to talk about. The second thing is that the projected impacts of climate change on Montana's streams, specifically on our cold water trout habitat, our fish populations, and other recreational resources, is a legitimate concern for stream access moving forward, and one that will color and we've already heard a bit about that today, but one that will color our approach to stream access as we move into the future. So there's not a great number out there, or not a great data set that we can draw a direct, explicit quantitative idea about what stream access has brought to Montana's economy. But it's really helpful to remind ourselves of what we all already know, but are important specifically in the context of stream access. So the outdoor recreation industry in Montana, all sectors, generates $7.1 billion in annual consumer spending. It's huge, second only to agriculture. Creates 71,000 jobs, $286 million in state and local tax revenue. 81% of us, I'd argue more, participate in outdoor recreation. And a good chunk of that has to do with stream access, whether it be fishing, floating, hunting, and other activities around the stream. 700-800 jobs are directly sustained through hunting and fishing industries alone. And so there's a connection there that we need to recognize moving forward. One of the best data sets comes from some colleagues at the Institute for Tourism and Recreation Research that discusses, every year does a survey on non-resident travelers to Montana. And a number that pops out near the top is daily spending averaged out on outfitter and guide services. And a lot of that money is generated in the summer, and much of that money is generated through fishing guides and floating guides. And the numbers are preliminary for 2017, but they put that number at 12%, and they put it at $380 million. So it's growing. It's an important change to recognize in the context of stream access. The second piece of information I'd like to bring to the discussion is information from my colleagues at the Montana Climate Assessment. And I see actually a couple people that worked on the report here in the room. But it was a 2-year effort by Montana State University and the University of Montana, led by the Montana Institute for Ecosystems, to assess all the data, hydrologic. There were 3 main components: hydrology, forest, and climate. And to assess all the data that was available to project into the future what climate change is going to bring to Montana. And so I focus on the key element of the climate assessment. The key lesson is that temperatures in Montana are rising. And there's, of all the sections that were, the 7 climate divisions that were divided in the report, you can see that every one of them is non-stationary, right? Temperatures are rising. Over the last 6 decades, temperatures have risen around 2 to 3 degrees. By mid-century, we're looking at 4.6 to 6 degrees. By the end of century, we could see temperatures rise, average daily means rise to up to 9 degrees. And so with that temperature rise comes some implications for our reservoirs, for our storage reservoirs, our snowpack reservoirs, and our streamflow reservoirs. Montana is a headwater state. We export water. This map shows that we've got about 41 million acre feet of water that leave the state a year, with an input of only around 13. And so we're a net exporter of water. And most of that water comes from our Central Rockies and our snowpack reservoir. And with rising temperatures, snowpack is dwindling. The bigger the red dot on this graph, the more percent change over the next, or in the past, from 1955 to 2016 in our snowpack. Yeah, I'm sorry. I promise at the end I'll be a little happier. We just have to drive down into the heart of the change here. And that has direct implications, and this is the connection that I think is really important to remember, is that snowpack not only has direct implications for actual surface flow, for the runoff flow, but it has massive impact for our late season flow. So that snowpack is the direct contributor to our subsurface shallow aquifers that feed our rivers in July and August, when the rivers are tapped. There's a ton of straws in the river, and irrigation season isn't over, and we still need base flow for our cold water trout habitat and some of our other aquatic species habitat. This is where it comes from. It comes from this subsurface shallow flow that's fed by our snowpack. So this is kind of a little hard to see, but these are 8 representative streams across each of the Montana climate divisions, and each has an associated graph with it. And when you see these boxes above the line in the middle and below the line in the middle, that is the average change in the timing of the runoff. So if you look at one of these graphs just quickly, that's January of a year, that's December of a year. And so what we can take away from these graphs is that most all of our streams projected into the future, we're going to see runoff happening earlier and earlier, and we're going to see late season flows declining more and more. And this has direct implication for our coveted blue ribbon trout streams and our other aquatic freshwater habitat. The top map shows you where the more red the stream, the less likely it is to be substantive habitat for our cold water fishes. And add 2 degrees Celsius to warming temperatures in streams that happens from groundwater flow and happens from an earlier season runoff. You see how that habitat starts to decline towards the mountains. So this is a major issue that we're going to have to grapple with when it comes to stream access. And so I pose, as the non-lawyer in the group, I pose a couple of points to discuss how we start thinking about that in a creative way. And the first one is not necessarily a point of how we start thinking about it, but it's more of a point of interest, and it's meant to be provocative, and I might be wrong. Actually, there's probably a good chance I'm wrong. But the idea of the ordinary high water mark, is that going to become important in the future? If you read the definition of the high water mark, which I won't read right now, but it talks about the characteristics of the stream banks above this mark and below this mark. So with earlier runoff, and we don't project that our runoff is going to change in total, but we project that the peaks are going to be a little lower, right? It's going to be earlier, it's going to be more sustained, and they're going to be a little lower. So does our ordinary high water mark change? And if it does, is there some issue of historic use? How do we start to deal with issues around that definition? The second piece is this maybe the importance or the increased importance of administrative closures, balancing these tensions between species habitat and access. And when it comes to administrative closures, the Commission and Fish, Wildlife, and Parks has the ability to enact these closures where it adversely impacts fish and wildlife, altering natural areas or biotic communities, and degrading water quality, obviously, and riparian property owners. But it seems to me, in reviewing some of the administrative closures to date, that we haven't really fully taken advantage of the ecological benefit of these administrative closures. And so we might see those on the rise in the future. And then the last one is this idea of private petitions for closures and limitations. Is this a place potentially where local riparian owners on the stream, around the stream, can start to notice increased pressures, notice change in the habitat of fishes, notice catch changes, notice economic effects from less tourists? Is this a place where on the stream, instead of just looking at these petitions for damages, but looking at these petitions as a way to get the Commission's attention and to perhaps protect some of these for ecological value in the future? And then the last point that's not up here that I'll mention is, will we, in the vacuum of these, or in the presence of some of these that don't work for Montana citizens, will we start to see more collaborative efforts like, say, we see in the Blackfoot Challenge, where we have minimum voluntary targets, and we've found collective action ways of moving forward to protect access to our streams vis-a-vis the fish populations that drive people to them. So with that, I will pass it to Michelle to talk a little bit about the intersection of this issue and the public trust. Thank you.
And I have been the time Nazi all day. I have to follow my own time rules now. We'll see how I do. Keep them really short because we value your question and the conversation. Look, yeah, this is payback. This is payback from Ron Waterman. Yeah, put the 2-minute mark up right now. This is perfect. I love it. So a few years back, I actually wrote a law review piece exploring the question of what is the relationship between the public trust doctrine, which evolved, as Jim told us this morning, it evolved out of these navigability and ownership the government ownership ideas, and how does that relate to this other completely separate body of law, which is water rights law? And he alluded to the Mono Lake decision, where the California court actually said this is the collision of two different areas of law, and we have to figure out how to balance them. And so I was really interested in not only how other states around the West have been trying to balance these two areas of law, but where things could head in Montana. And Judge McEllier alluded to the threat of litigation as a motivator for our in-stream flow leasing laws. And so when I go through the possibility of there being a competition between these two laws, I'm aware that litigation is one avenue, but where my mind goes is how can we again use our coalitions that we heard about throughout the day and our collaboration to continue developing ways to honor water rights and the needs of our water users along with the public recreation rights. So it's partly academic, but it's also partly personal. I come from a ranching family, and I come from, on the other side, a family who loves to hunt and fish. So in my mind, I'm thinking, how do we do these two together? And I just gave you the site to my article. All of these pieces today, all of the slides are available on the event website too, if anybody really wants the slides and they want to, I know they're going to go back and analyze all of Brian's data very carefully at the end of the day, right after the pea shooters at the Irish sing-along. You can go back and look at all of our slides, but they're available to you. And so we've already heard some ways that the public trust and water rights law are working together. In particular, some of the in-stream flow laws that Judge McEllier, Stan Bradshaw, and others mentioned. Another area that we actually have experts in the House who worked in this area is voluntary efforts under the Endangered Species Act. So we have, for example, the Arctic fluvial grayling and the big hole, and the voluntary efforts there of irrigators to reduce water usage in order to bring the area into a situation where maybe there won't be a listing of the Arctic. Do we know? Bill's been he argued it in the Ninth Circuit that the state of Montana can adequately protect the Arctic fluvial grayling, but we don't know yet. But it's another example of how, in this case, a federal law might be used as an incentive in federal funding and state funding and private funding to work together in honoring both the water rights and the recreational rights. Professor Mills is going to talk about the next one. Judge McEllier also talked about tribal and federal rights and how they could be a building block to flows. And so I want to look at this last one, which is, what about considering the public trust during permit review and change authorizations? Oh, now I'm scared I said it out loud. Okay. And I want to talk about what I see in the case law in Montana right now. It's pretty preliminary, but also then what some other states are doing. And I have 7 minutes left on Waterman. Okay. And so at the beginning of the morning, we heard how this amazing decision in Curran and in Hildreth, it recognized in Montana Constitution, Article 9, Section 3, it read in the right of the public for recreational use of waters capable of recreational use. And it read that into this provision, which also recognizes existing rights under the appropriative doctrine and says that all the water belongs to the state for the use of its people, subject to appropriation for beneficial use. So we right there at the constitutional level have two different uses going on that both have to be accommodated. And so as we go forward into the future and our climate data doesn't look great, how do we do that? And maybe the way we look at water rates and permit them in the future, maybe we could begin folding in public trust notions as well. There's an interesting sentence in Curran, which I put up on the screen, which is dicta. It's not part of the holding, but the court said that Curran, I have this vivid image of him now running over a raft. I can't get out of my head. Curran has no right to control the use of the surface waters of the Dearborn to the exclusion of the public, except to the extent of his prior appropriation, which is not at issue here. So there was no tension in that case between the amount of water he was taking out of the system and the recreational use of the system. And that wasn't part of the case, but it's an interesting sentence, right, to grapple with. And then we see it kind of fade away down the road in more recent decisions of the court where they summarize the holding in Curran. In Bean Lake 3, who knew one little lake would spawn 3 cases? In Bean Lake 3, where the court actually recognized in-stream flow rights predating all of those interesting statutes that Judge Mapouillet went through. The court said, actually, before our Water Use Act and the Murphy rights and the Fish Wildlife Park rights and the private in-stream flow rights, we would recognize a non-diversionary recreational water right that is senior. You would have to prove that you intended to develop this right way back when, in the olden days, but there are some of these rights claimed in front of the water court, and the court said under the Montana Constitution and the public trust doctrine, the public owns an in-stream non-diversionary right. So the court describes it as its own kind of, almost like a water right, right? The public owns it for recreational use. And then in 2011, the court also recognized that Trout Unlimited had standing to appear in the water court and object to water rights claims, even though it didn't own a water right. This was in the Big Hole, right, Sam? Yeah. This was in the Big Hole. And there again, the court, citing and summarizing Curran, said the Constitution and the public trust do not permit a private party to interfere with the public's right to recreational use. So we don't have the court carrying forward that appropriative language that we saw in the dicta of Curran, but I think it remains kind of an unresolved question. I think there's another interesting unresolved question. And if we move to another part of the Montana Constitution with the clean and healthful environment right, and in that part of the Constitution, we have this duty of the state to maintain and improve a clean and healthful environment. But there's some interesting stuff about the legislature protecting environmental life support system from degradation and providing remedies for unreasonable depletion of natural resources. And if we think about the landmark decision of MEIC versus DEQ, the law that got struck down there was a law that allowed an activity without adequate review. And the activity was going to harm the fishery, right? It was on Landers Fork of the Blackfoot River. And so there's this other provision that hasn't really been connected. I'm getting the 2-minute warning. How is this possible? This is so fair. It's totally fair. Ron is gleaming right now. But it's interesting to think about this provision and its mandate that we don't allow depletion. And how does that work with the natural resource of our state, water? And if we are in then a permitting system for our water rates where we don't normally factor in public trust. I actually found 2 DNRC agency orders from the 80s where one administrator talked about the public trust for a hydropower permit and another where the lake level was going to get lowered. And that's it. It's radio silence. If we contrast that with a state like California, when you get a new permit today, it says on it, subject to a modification as needed for the trust. And we also have states like Washington saying minimum flows are going to be set and any new permits must protect those minimum flows. In Montana, our basic water right permit, you have to look at something called the existing legal demands on source of supply. And we've always thought that to mean who are the other water right holders. Could it also mean legal demands under the trust? Question mark. For large appropriations or out of state appropriations, I think we do have language in place that would allow that kind of consideration. So those are very provocative questions. You can read my article to hear more about what other states are doing, but thank you for listening.
Well, good afternoon. I think it was Dana who said earlier she had 4 slides. I'm going to beat her because I have none. So I figured by this time in the afternoon, it'd be all I could do to keep your attention just by talking. So rather than put text up, I don't have slides. But I am going to stand up anyway. And as the one with the privilege and the honor of speaking last before handing it over to the governor for final remarks, I'd be remiss if we didn't take a moment just to thank Professor Bryan for all of her hard work. The work with Ron to do this has really been phenomenal. I'm fairly new to Montana. I came here in 2015 to join the faculty at the law school, and I also have the honor to serve on the board of the Clark Fork Coalition, so I've been in a crash course on these issues, and everything that's been discussed today has been fascinating, so I really appreciate the opportunity to be here. So when Michelle came to me as she was planning this months ago now, seems like a distant memory, and said, hey, I'm putting together this panel on the stream access law and the history. Would you like to come talk about tribal rights and tribal law and how that intersects? And I said, sure, yeah, that sounds great. And then I started thinking about, well, wait a second. If you're talking about stream access in the state of Montana, we're not really talking about Indian country, are we? We're not really talking about access to streams on reservation. We're not really talking about the application of tribal law. We're talking about the history of state law and this great tradition of the public trust and the clean and healthful environment and the integrity of protecting that and the use of the state's waters as recreation. But as I got to thinking about it more, it seemed to me there is crossover. And sitting here today, hearing about these discussions, it seems to me there's really 3 things we could talk about when it comes to tribal and federal Indian law rights and the questions of stream access. One is intersections between the history that you heard today and questions of tribal rights and jurisdiction. 2 are parallels between the history that you've heard today and both sort of present and future questions raised by tribal rights. And then 3, we can talk about the future, because as you've heard briefly today, it's my position that the future of stream access, not the technical legal right of access to the stream, but the stream itself and being able to access the stream in the future may be intimately tied to the rights and authorities of those who've been accessing these streams since time immemorial. And that's the tribal folks of Montana. So how do these things intersect? Well, you heard discussion this morning about the case down on the Bighorn and the equal footing doctrine and the arguments put forward by the state of Montana about ownership of the riverbed and how the legal title of navigability really was sort of part and parcel of the ongoing stream access debates. Well, that case arose about the bed of a river that had been reserved in the 1800s to the Crow tribe for their absolute and exclusive and undisturbed use and occupation. Now, the treaty didn't say including the riverbed and banks, and the Supreme Court of the United States largely relying on the equal footing doctrine and the notion of state sovereignty and coming into the Union on the same basis as other states, decided that the state owned the riverbed through the Crow Reservation, notwithstanding that treaty language that had otherwise reserved the Crows' exclusive and undisturbed use. While that then set the stage or supported ongoing stream access and the state's rights in beds and banks of the rivers, for tribes that had a very different implication and has had very different consequences, not so much in terms of stream access questions or natural resources, but that decision has then laid the basis for future decisions of the Supreme Court, which have continued to restrict jurisdictional authority of the tribes, particularly over non-Indians, and especially on non-Indian-owned fee land. So to the extent there's intersection between the roots of the state's rights to stream access and protecting those rights, those implications for tribes have been very different. And tribes, in many ways, as a result of that decision, have been unable to control or regulate access to their streams, particularly where those streams are owned by non-Indians and particularly where non-Indians are accessing them. So there's an intersection there and a different history, really, since that decision for tribes. But in other instances, and with other treaty language, tribes have engaged in much the same process, fighting over control and access and regulatory authority over their streams and lakes, both in the courtrooms and elsewhere, largely in the courtrooms. And a number of the folks who you heard from today have been involved in some of those cases. Jim Getz, for example, working on cases up at CSKT related to the stream, the joint board cases. And where tribes, like the Confederated Salish and Kootenai, have treaty language that reserves to them exclusive rights to use and fish within the waters of the reservation, courts have generally upheld those tribal rights to then control and regulate their own streams, notwithstanding earlier decisions of the Supreme Court, like Montana versus the United States. Okay, thank you. Thank you. I'm glad you're fitting right back into your role. I appreciate that. But in that sense, too, there are parallels, right, between the tribes and tribal authority in controlling stream access and the history of state stream access. Sure, there have been litigated fights, and there have been contests where the winner takes all, and as Judge McEllier said, a disinterested third party makes a decision that neither party is ultimately happy with. But like in the case of the CSKT, there's also been coalition and compromise and agreements, particularly between the state and the tribes, about hunting and fishing regulations on reservation. And so there's also been coalition building that's led to some success. So there are parallels, I think, we can look at in the context of tribal rights and questions of stream access. But going forward, what are the questions really that tribal rights, federal Indian law, tribal authorities might pose for thinking about the future of stream access in Montana? Well, like those treaties and like those treaty rights we've talked about, and even before the times of treaties, tribes were engaging in aboriginal uses of these waters. Many tribes reserved those rights expressly in treaties, and the Supreme Court has engaged in centuries, at least a century, of deciding what the nature of those rights are. All the way back in 1905, the Supreme Court was deciding that, yes, tribes have reserved access rights for fishing in treaties across the Northwest. And in 1908, the Supreme Court said, yes, the reservation of a particular land, a particular reservation on behalf of the tribe also reserves a pertinent water right. And those time-honored decisions, over a century old, protect tribal rights both on and off reservation that may impact streams and stream access, or access to streams, whether streams are there or not. We can think about both of those things, reserved water rights and treaty reserved off-reservation rights. And as we know here in Western Montana, both of those questions are particularly relevant for thinking about right now, because now is the time that decisions will be made and things will be implemented that will affect the future. With regard to reserved water rights, for example, if we're going to talk about fights and coalitions and battles in the legislature, we can certainly talk about the Water Rights Compact for the Confederated Salish and Kootenai tribes, right? In some ways, a parallel in terms of legislative battles like the Stream Access Bill. But yet, it also resulted in some coalition building and secured, in order to prevent further litigation, in-stream flow rights for the tribe, off-reservation, in many of the streams across western Montana. And so how will those rights be protected, exercised, implemented, used? How will those rights fit in with the potential changes of climate change, lower stream flows, increased recreation rights, or the wealthy folks that may be coming to Montana and purchasing land on stream beds? In addition, however, that's a present issue that may affect things certainly in the future. Even more pressing, in about a month's time, the United States Supreme Court will hear arguments about the extent to which treaty reserved rights to hunt and fish also require states to protect and ensure those rights continue. And in that case, the United States versus Washington, arising just next door, but from similar treaty language as treaties here in Montana, states have taken the position that just because tribes have a treaty right, that doesn't prevent the states, or doesn't mean the states have to be held accountable for not building culverts that maybe destroy salmon runs. And while that question, culverts and salmon runs and road construction, may be fairly narrow, the potential implications for that decision are pretty big. What do treaty rights require of other parties with regard to protection of natural resources? And for our discussion today, particularly with regard to protection of stream resources, especially where there are more and more pressures on those streams. If today it's culverts, and depending on how the Supreme Court rules later this year, we will certainly know more about that scope. What is it tomorrow in terms of the potential for treaty rights to require the protection of water, fish, wildlife, etc.? So to me, and maybe to wrap up if time is short, as I know it is, to me there's immense power in both treaty reserved and reserved Aboriginal rights, water rights, to be exercised by tribes. And as we have seen in headlines over the course of the last couple of years, there are more and more instances of coalitions coming together to support the assertion of those rights by tribes. It seems to me, in terms of parallels and lessons we've heard today, those coalitions have to include Native voices, and ideally, maybe Native voices at the lead of those coalitions in order to ensure that the rights all of us are interested in securing for stream access and the future of these resources are protected. So thanks.
We have the luxury of just throwing out questions at all of you and expecting that the people in the real world will solve them. But what questions or contributions do you have? We have about 5 minutes, and then the governor is going to come up and speak. Tom, speak loud and proud.
Can I ask, do you believe that the Bighorn case allows full implementation of the stream access law in the reservation?
Depends on the reservation. And I mean, really, because the language of that case turned on the specific history of the Crow Reservation, and then the jurisdictional questions beyond the equal footing doctrine decision also were sort of unique to that particular situation. I think it's hard to generalize, which is to generalize. It's generally hard to generalize about Indian law, but particularly in that case, I think there were some pretty fact-specific decisions that made it applicable there. That being said, I think the United States Supreme Court since then, and even to some extent before that, has been unwilling or really unable to look at sort of those specifics. They've been looking for a bright line rule. So would the Supreme Court apply it to other reservations? Maybe, but I think there's reason that to say it's specific to that particular treaty, that particular reservation, and that particular history.
The Confederated Salish Kootenai tribe could pass a resolution that says, no, white folks don't have the right to go down the stream to the high water.
To the extent the language of the Treaty of 1855, the Treaty of Hellgate, reserved to the tribe the exclusive right to fish on the streams, I think that makes it a different consideration.
Ooh, he
How
has a
about that?
very careful answer. One of your areas of expertise is tribal state co-management of wildlife. Would you want to take a few minutes or seconds to talk about?
Sure.
I just think it's a cool model that many people don't know of.
Yeah, and I mean, again, as you've heard all day, right? The building of coalitions and the finding of common ground to really avoid winner-take-all litigation outcomes is ideal. And in instances where there either are treaty rights or not, it really is a winner-take-all proposition. And so, to the extent tribes and states are able to reach collaborative regimes in which they can both preserve some of their interest, it seems to me that's the path forward and would avoid a century of litigation, which is essentially what we've seen in the Northwest fishing cases. And I think that there are examples of successful co-management of wildlife resources, natural resources. The Northwest fishing cases, for example, have begun and really resulted in the development of the Columbia River Intertribal Fish Commission and a lot of sort of technical and legal capacities for tribal assistance in management. And it seems to me those are models for the future, hopefully.
Brian, do you want to add to that? You've done a lot of work in the Columbia.
And I didn't mention this earlier, but even though you might think I'm a doom and gloom climate scientist, I'm not. I mean, I actually just I think it's really important information for us to know. But I'm a social scientist who looks at collaboration across watershed groups. And as Professor Mills mentioned, we are seeing that around the element of water more and more across the world. Water is one of those universal elements, mostly because it's a universal human right, that folks are able to come to the table in a more willing way. And places like the Blackfoot Challenge, places like watershed groups across the United States, some of the key things that we find in meta-analysis of these are what we've heard in this room that built the stream access law: charismatic leadership, risk-taking. And so those are some of the things that they're intangibles, and they're not things that we can build into our administration of the law, but they're things that we can build into our coalitions moving forward, and knowing that they're critical parts to taking the next step in the face of certain change.
Brian talked about the changing patterns of runoff, essentially, and can you just talk about the effect that that could have over time in the adjudication process in terms of people's property right and period of use associated with water rights?
I don't think there's an answer right now. I mean, in you get this nice certainty on paper from the adjudication process, which is your period of use, and it may no longer align with the hydrograph. A period of use is not a change that triggers agency review in front of the DNRC. So do people naturally just adjust their period of use? What kinds of harms result from that? Do we need an agency process for those changes? Or will it default to a litigation posture for injuries that aren't addressed in advance through agency review? I think it's a really hard question, and it will ask the state to think about that word usufructuary, and right, that we have the right to use the water, but it belongs to the state. So to what extent can they move around the uses that we think of as more baked in as far as historic period of use.
And from a habitat perspective and a recreational fishery perspective, I think that it also changes the emphasis from the law to monitor, to not necessarily adapt and manage, but at least monitoring so we can adjust in real time with things like petitions and administrative measures, putting an emphasis on that.
Yeah, the admonishment earlier to do things surgically and locally and resource specific, I think, will be really important. Users coming together to figure out how to rotate and use water differently. We have time for one more question in the way back.
So I work for the Forest Service, and there are some state laws in the Northwest that don't allow the U.S. government to hold in-stream flows. So that forces us to look for partnership opportunities there. And I was wondering if the tribes have any rights to hold in-stream flows, specifically Washington and Oregon.
I can't comment on tribes in Washington, but that was a significant part of the compact's adjudicating and confirming the water rights of the Confederated Salish Kootenai here in western Montana, where in-stream flows.
And I'm looking out at Fish, Wildlife, and Parks attorneys. What do you see as the big issues ahead, or what would you add? Becky.
Not to put you on the spot.
May. Obviously so much has been covered. The evolution of the public trust concept here with respect to water is, I think, you agree, there's so far to go with that, and who knows where it'll go. I think it's pretty unpredictable. But a couple of things I'd like to add. One example of collaboration under the Salish and Kootenai Compact that we're going to need to be dealing with when that compact's ratified is that we have an obligation in there, because many of the off-reservation and stream flow water rights were set up as sort of very parallel to FWP Murphy rights west of the Continental Divide. And there is an obligation in there not to co-manage. We were very realistic about it, and that, who knows? Can we really get along that well? Can we really serve as effective co-managers? But there is an obligation to meet and discuss and see if we can get on the same page and agree on management. And I think that's going to be a very interesting collaboration as we progress, as well as not only all the existing Murphy rights, but implementation of the in-stream flow associated with the old mill town. That was a big part of that compact too. And then finally, I want to put in a little bit of information that you may not know that is relevant to a very tangible threat to all of us. Stream access, in-stream flow, irrigation, collaboration, watershed groups. We are rapidly losing funding for USGS real-time gauges, where we're really taking a hit. It's been more and more cost share. The states have had a larger piece in that over the last several years. And then our agency, my agency, has had impacts to our fisheries budget, and we're able to put in less. So we are dropping gauges, and that is going to be very hard for water management in the state.
I would add to that, this is Becky Doctor, I'm Chief Legal Counsel at Fish, Wildlife, and Parks after Bob Lane. He was my boss for about 12 years, so all three of you have brought up compelling points that we've dealt with on, semi-regular basis. The points about the petitions and the administrative closures are very pertinent, and they're already happening. We've seen an increase in petitions from individuals to limit and mostly restrict right now, not yet close, but to limit recreational use on the streams already. And most of it's because of a conflict between users, but as we get more and more into climate change and change in some demographics of the streams that we've heard others mention, we're going to have more and more of those. Over the course of my time at Fish, Wildlife, and Parks, there's been a dramatic increase for petitions from individuals. And so all three of you made some, actually all day long, there was some discussion about collaboration and working together and pulling people together and leaders from communities and different sovereigns. And that is compelling to me, because sitting in my job, getting the petitions and having to react and having only, the statute book to go by, that limits our authority, limits where we can go and what we can do. But the more the people outside, leaders, other leaders are coming together and pulling together and finding legislation that can help address some of these issues, I think is a place that we're going to need to be, is an absolute necessity. And that is, I took that as a theme today and spoke to me in real ways. You just ended our talk.
I'm excited to have Governor Bullock, and Ron Waterman is here to introduce him. And then please stick around for the celebration afterward, just downstairs. Nobody wants
Thank you very much. I'm not going to take very long to introduce the next speaker, Governor Bullock. I've known Steve since he was in high school. I thought about that the other day. One of the first times I remember meeting Steve was when he was about ready to graduate from high school, and my wife and I went to Steve's house to meet with his mother, Penny, because Penny was looking to try and put together a quilt from all of the T-shirts, of all of the activities that he did, and she didn't know exactly how to do that. My wife was a quilter, and so she helped do that. But I thought it was an interesting reflection upon Steve then and Steve now, that he understood even then that to be a whole person, you have to stitch together these various events across the board, putting patches and pieces together to make a fabric that embraces you, that makes you a whole person. We heard three things today, and I think if you came away from this conference with nothing else, those three things were collaboration and building coalitions, common ground, and listening. And I would submit that we fortunately have a governor that epitomizes those virtues, because that's what Steve has been able to do to make him a successful governor. He's listened to people. He's found common ground to make sure that the policies that he espouses affect the common good of all people in the state of Montana. And collaboration. If you've watched the legislative sessions, you've seen Steve reach across aisles to bring people of diverse political views together to focus on what's best for Montana. It is a pleasure to introduce him.
I brought my own. First, thank you, Ron. A generous and kind introduction. And typically, whenever anybody begins with, I've known him since high school, I could be in a hell of a lot of trouble. I so appreciate your indulgence. I was supposed to be here as the first speaker. My fifth grade son had a report on states that I thought I'd better go to. But to tell you the truth, it would have been a heck of a lot easier to be the first speaker in class. And I say that because you've been among the giants today. The giants that not only shape the litigation, not only shape the lawmaking, not only shape the overall public discussion, that they were the foundation in everything that made the laws that we have now truly and fundamentally, I think, the envy of the nation. So I wish I could have just said welcome and gotten out of here. And I would never want to even try to measure up to the folks that you got to hear from today. I think that my education of recreational access and the importance of what we've been talking about in many ways came long before I went to law school. That my summer job through college was being a tour boat guide at the Gates of the Mountains. And before that, I was a gas boy. When I was going to then apply for law school, I wrote about, in part, about sort of the church of my youth. I had an older brother who would drag me through where the Beartooth Game Management Area is and others, into sort of the backcountry, little creeks and streams. And that's where, in part, I think, was my ground. Never forget, I ended up going to college, a small college outside of Los Angeles, and I'm already getting nervous that if I go too far away, Michelle's going to gallop me down. But so my last year before my senior year in college, I was outside LA, and I had this opportunity to go work at this investment bank or something like that. This great internship that could lead to something wonderful for your future. And I said, I will never have a chance to live along the Missouri River. Because it had a little one-room house out of the marina at Gates of the Mountains. Along the Missouri River, the longest river in North America, stretching 2,740 miles. But so I chose for that to be my place, because it was a place of grounding. And fast forward a handful of years, I show up at the Attorney General's office under Joe Mazurek in a cubicle. The only way I finally got that office is because my voice was so loud that everybody's like, we gotta get Bullock out of here because he's bothering people. But he provided me two incredible opportunities that I didn't even know would have a chance to both impact what the history of this discussion is, but also impact my political life. And first was, there was a fairly contentious issue along the Ruby River. Imagine it's not the first time you've heard that today. But it had to do with recreational access from streams, or two streams from highways, bridges, and abutments. And they had asked for an Attorney General opinion, which has the force of law until the court says otherwise. And Bob Lane can probably remember as well, or better than anyone, that my time both working in the Attorney General's office and serving as Attorney General, never had an AG opinion garnered that much comment and concern. And I was just a few years out of law school, and Missouri says, all right, Bullock, you figure it out. And I don't remember what all Bob, because for an AG opinion, first you write a draft. I don't remember what all was in that, but as dug in, it seemed like we had these incredible rights and a right of way in all of our streams. And it's just where two right-of-ways cross. And you ought to be able to take advantage of the full easement. That was one of the defining moments. And another one was, I don't know if you guys talked about Madison versus Graham. It was when a guy, James Watt, William Perry Penley of Mountain States Legal Foundation, decided to sue to get rid of all the good work that had been done before on the substantive due process claim. And when it comes to recreational access. And I'll never forget, I got to go to federal court. I was representing all of us. Like, my name's Steve Bullock. I represent the people of Montana, and these rivers and streams belong to all of us. Now, don't PolitiFact check that. I don't quite remember what the transfer is. But what I do remember is, like, this is the coolest job in the world. This is the most amazing job in the world. So shortly thereafter, I ran for Attorney General, and I don't think my whole family voted for me. I don't know if you've heard of me, it's now the Chief Justice, Mike McGrath. But yeah, in 2000 I ran, in part because I was inspired by, look at what I got to do, something that tied for my youth. and going along the rivers and the streams to standing in court, not just representing a client, but representing all the people of Montana for something that is a bedrock importance to so many of us that live here. I was asked to speak in part about the role that stream access played in my last campaign for governor. I don't know whose idea that was, but okay. Before I even get to that, I'd say though that maybe perhaps more importantly, the role that stream access played in everyone's lives. Because when I ran for Attorney General successfully 8 years later, there were ads about stream access. And a lot of my talk was about stream access. When I first ran for governor in 2012, the same both what we had accomplished and what we, as Attorney General, and what we could look forward to. And then in 2016, both that on the positive side and on the little bit more challenging side when my opponent sued me in recreational access near his home. But I underscore that because I'll never forget when I first was running for Attorney General. I wanted to talk about stream access, and in part, it was because campaigns reflect the values that you hold, right? But in part, I fundamentally believed that it was an important issue. And the pollster said, you want to talk about what? You want to talk about people all being able to get into streams or rivers? I said, yeah. And it resonated, though. And it resonated in ways, and it resonates to Montanans, no matter where we are, where we come from. It resonates in a way that I think transcends sort of contemporary political divides so many times. And I think in part, it's because it's one of those things that I call that great equalizer. That it doesn't matter how wealthy we are, what land we own. It doesn't matter what family we were in. We all have an opportunity to access it. And then we all have the opportunity, that same fifth grader that I learned about in Kentucky, the state presentation this morning, was like, Dad, can we go maybe ice fishing this weekend? If any of you are good ice fishermen, I have an 11-year-old who'd love to go. But it's something that is generational. And it's as a public or a great equalizer, it's generation. And I have no doubt that you've heard, I think back to my Attorney General days, I have no doubt that you've heard at times about some of the contention and the divides that have occurred when it comes to stream access. But I also think about the coalitions that were built in 2009 when we took what was deemed as a controversial AG opinion that made a hell of a lot of sense to me about access from bridges and abutments, and then somehow got it passed through legislature in a way that landowners and recreationists could say, yeah, this is important, and this is part of what Montana is. And we've just got to make sure that we can ensure to find the ways to make it all work together. One of the other things when I was Attorney General, and I don't know if it was discussed here, but you have to give both many of the lawyers and others, the PLWA folks, so much credit for fighting along the way where there weren't always other areas or other groups or other state entities that were stepping up in the way that they would. And can think of two different areas where one was Scenic Road in Terry, Montana, and then the other was Tenderfoot Creek, kind of near the Smith River, where during that period of time, so that's 2008 to 2012, seems like, at least from my perspective, we're seeing more and more gates on roads. And Near Terry, one came up, and I, of course, said, "Hi, Steve, I'm the Attorney General. I'm here to help you." And while as I can look at the 2009 legislation dealing with recreational access that transcended partisanship, don't kid yourself, when somebody from Helena comes to Eastern Montana and says, "I'm here to help you," there's still a little bit of challenge. So the county commissioners feel, I don't need it. I don't want it. We need to figure out a way to do this. But in the, I think it's the 10-foot case, we did exercise more or less the independent authorities that the Attorney General has to get involved in that litigation. And it's something that as we go forward in this, that I think, and I haven't logged on to Lexis lately, but that there's good language in there about sort of the ability for an AG to uphold that public trust doctrine and get involved when it comes to access in places that maybe sometimes either a local county attorney or others don't want to. Last campaign certainly did have some discussions about stream access, but more than that, too, is about public lands and the threats that we have in many respects to access public lands. We talked quite a bit about, and we formed the DNRC Public Land Specialists. The idea is that both to work with landowners, we know that we have about 2 million acres of lands that are landlocked, that there is no access to. But to work with landowners to try to negotiate ways to get easements or other things. And also, ideally, if that's all you can do is to sue to take what were traditionally public areas, access lands, and reopen them out as we go forward. Talked a lot about Habitat Montana, which is a program that's paid for by sportsmen's dollars to acquire access and acquire lands for all of us to use. And for a while, our legislature said, no, even though it's sports, recreationalist dollars, that we shouldn't be in the business of buying any more land. One finite thing that we know for sure. And also then forming an office of outdoor recreation. The professor had some slides, but at the base level, I always say, we're a state of 1 million people. We have 12 million people visitors that are coming for our Walmarts. They're at home. They're coming through these incredible experiences that we can have indoors. And our stream access laws are fundamentally part of that, and our public lands are even more than maybe running on recreational access. Stream access, though, is like the terror that I felt in some ways when I had to make a decision to close the Yellowstone River, right? Our rivers are heating. Things are changing. And the idea kind of at the heart of what is the economic driver in Livingston to say, all right, we're up fish kills, no more one river. But what was amazing to me in so many ways was how guides, how local communities, how others said, this resource is so important to us long term that even if this ruins my year, or ruins my season, if that's what science says, we better do it. And how what could have divided communities brought them together. It reminds me that when I was running for governor, I learned that there's 2 ways to become a scientist, wildlife biologist. One's to come here and get a master's, the other is to run for office. So, but the moments where then we can sort of step back and say, these resources are so important that let's actually listen to the scientists, I think are so important for all of us. I think one of the reasons why to be here, though, today for all of you, don't worry, Michelle, isn't just to be among the giants that proceeded to be good. And it's not just to be nostalgic about the history of what's happened. But it's to remember that we need to both understand and completely absorb the history, because if not, it will quickly repeat itself. And I'd love to turn around and say that the threats to stream access, the threats to our public lands aren't real, just used to further divide people in politics, but I don't think that's the case at all. I think back to American Lands Council, which is a legislator from Utah. It's talking about transferring federal lands. And his first, when he was pitching all throughout the West, his video that he used had a lot of me speaking as a governor. Like saying, talking about fires and what we ought to be doing better. But it's a reminder that, yeah, we can always do better and work with and sometimes work against our federal partners. But the idea that, the simplistic idea that we're just going to transfer these lands to the state and somehow life will be great is absurd, because at the end of the day, those lands would leave our state hands and be privatized. This last year is a perfect example, right? Most expensive fire season we've ever had. $72 million the state of Montana spent. Feds, north of 400. The threat is real. It's in both, not to get partisan, national Republican Party platform and the state party platform has been, we need to transfer these lands. And transfer those lands is the first step ultimately towards selling them off. And the threat is real, I think, because, as I said, one of the most finite assets that we have in Montana. And Montana's becoming, I think, much better known than since many of us were kids. Is the land and the landscapes and the access and the beauty to these streams and rivers. And where great amount of money meet beautiful places, all of us, the public, lose out. So notwithstanding the fact that there's a national group trying to transfer lands, notwithstanding the fact that it's in political party platforms. Also, won't forget, like a year ago, I think it was a year ago, where there was a rally during the legislative session about public lands in Montana. And 1,300 people at least showed up. These aren't folks that are engaged every day in the political system. These aren't just fly fisher people, big fishers, not just hikers, four wheelers. And it underscores that, to me, seeing this big group of folks, who it's always fun to go to a lot of things like this with people say, yeah, great meeting you. You know I didn't vote for you. Yeah, I know that. That's okay, because here's a unifying force. But it's so great seeing all those folks saying, these lands belong to me. And that was about the time that Chaffetz and others had a federal bill trying to transfer. And I'm not quite sure, but I think even all the way to Washington, D.C., they heard the voice of everyday Montanans coming up and saying, we're not going to transfer these on our watch. I think that serves as a reminder, not unlike some of the lawyers that helped out over time and not gotten paid what they should have, or the folks that sat around tables or went into county courthouses to do a little bit of research on where these established roads and access points, that at the end of the day, the power of maintaining one of these great equalizers still doesn't rest with the powers of wealth or the powers of government. It fundamentally does rest with the powers of everyday Montanans that are saying that access to that belongs to all of us. And we don't do it for nostalgia or to say it's great. We do it for the gifts that so many of us have growing up and the recognition that one of the best things we can do as we